would like to extend my gratitude and say that I'm thankful for colleagues who decided to participate here on the panel. It was really enriching for me, and I think that it will also serve me as a good ideas for my future contribution in my dissertation, which is slightly different, but also it discusses this topic. So as you see here, my title is Agreement of Succession in Serbian PrivateInternational Law, some remarks. So as we already spoke a little bit about the definition of and general notion of agreements as to succession, and of course there is a difference how it's defined in regulation, because there is autonomous qualification and definition of that, and also regarding some national law it can be slightly different. And of course a lot of ink has been spilled before the adoption of regulation on the nature of the agreements as to succession, and also taking into account that it's not a regulated institute in national succession law of Serbia. Maybe we can embark or face some challenges regarding the first qualification of the succession agreements of succession, in order to find which conflict of law rules should be applied on a given agreement of succession in question. Because as you will see, there are two different sets of rules. First one regarding contractual obligation. If we put focus on the contractual nature of agreement as to succession, as it's already done in some part of Serbian scholarship, we will have one outcome, substantive outcome. And on the other side, if we focus on its succession nature and its succession effect, we would apply different set of rules, and they will lead us to different substantive outcome. So here, of course, I notify that it's generally prohibited any succession contracting upon that. Otherwise, we have donation morti causa, which is not regulated by law succession, but it's widely applied and permitted. We have lifetime maintenance contract, a contract on assignment and distribution of property during one's lifetime. And it's really important to mention, taking into account our first idea, what I want to say, that our legislators strictly differ those disposition inter vivos which causes certain inheritance effects upon that from the agreements of succession. That's also the first starting point for us. So the main source of private international law in Serbia is the law on resolution of conflict of law with regulation of other countries. I will refer to it in the future as Z or as Z. And as I already hinted, it contains two different sets of rules. First one are devoted to succession, and they are contained in Articles 30 and Article 31, and other ones who are devoted to contracts are contained in Article 19 and 25, and also in Article 7 regarding formal validity of contracts. So, as you see here, our succession, our conflicts of law rule for succession follows so-called unity of succession principle, which means that it does not make any difference regarding movables or immovables. So the one same applicable law, which is the law of nationality of the deceased, should be applied in the succession as a whole. While in the paragraph 2, it stipulates that the capacity to make a will is governed by also nationality of the deceased, but here at the time of making the will. And here we have a general institutional law, which is applied in all civil and commercial matters regarding every legal category that is regulated in conflict of law rules. And it, for those who are not experts in private international law, denotes the notion that when conflict of law rules refer to some other country, the substantive law is not immediately applicable, but we first need to consult its own conflict of law rules to see whether they want to be, whether they want their substantive law to be applied. So, and of course, we have Article 31 of ZRZ, which provides that the formal validity will is determined by the rules of the Hague Testamentary Convention, and as you know, it has pretty long amount of connecting factors and follows the principles in favorem testati to hold the testament in force. And also, according to Article 3 of the named convention, we added one additional connecting factor, lex fori, just in order to follow the main spirit and structure of in favorem negotio rules in our law. On the other side, we have contractual rules. First one is, of course, party autonomy. Parties are generally allowed to choose whatever law they want, and also, according to our scholarship, the passage is allowed, so they can choose for one part of their contract one law and other law for other part of the contract. We have it maybe for you it sounds maybe a little it looks like a little bit strange structure of the Article 20 because it's not divided in particular paragraphs, but we have Article 20 points 1 to 11, which follows the principle of application of the law of the domicile or seat of the party who performs the characteristic obligation, and it regulates almost all contracts that are usually employed in practice, but for those contracts who are not covered, so-called unnamed contracts, it prescribed or designated a particular connecting factor, which, as you can see at the first look, somehow is not probably in line with the connecting factor employed in the Article 20, and it refers to the law of the state in which the offerer was domiciled or has his seat at the time of receipt of the offer. So later on, we will see how this particular rule can cause a problem regarding if we decide that the first qualification issue should be treated as a contractual one. We have escape clause, which says that if there is a law who is more manifestly closely connected to the contract would be applied then. Article 7, which is already mentioned, determines form and validity of the contracts, employing locus regit actum, more lex contractus as alternative conflict of law rule. And Article 21 provides that for all issues that regard immovables or estate, whether it's substantial formal validity, context, effects, or its meaning, interpretation, should be governed by the law where the property is situated. So as we put like general framework there, we can say that there are three possible solutions for the court dealing with the question under which legal category of those named sets of rules should be subsumed the question of agreement as to succession. So we can accept contractual qualification of the issue, but since we don't have specific conflict of law rule for contract as a contractual disposition of that for agreement as succession, let's say, we would then apply Article 20.2, which, as I already mentioned to you, but I will refer to it back, does not follow the principle of characteristic performance or the debtor of characteristic performance, his seat or domicile, and thereby it may contradict with the general framework of the ZRSE and its spirit. Second option is to treat the issue as a question of succession law, which is more sound and makes sense, and we will abide to that, but not just for dogmatical reasons, but also for some practical ones, and apply the rule of Article 30 of ZRSE, and then apply the low nationality of the deceased that he had at the time of death. And this is really important because this time fixation can determine whether we apply this rule or not. And the third option is to determine that ratio legis of conflict of law rule from Article 30 does not respond or didn't take into account by the time of its creation the agreements as to succession. So if that's the case, and we will discuss that shortly, then the question of agreements as to succession will be teleologically reduced from the scope of Article 30, and thereby we will determine that there is a legal gap which has to be fulfilled in accordance with Article 2 of ZRSE, and I will also come to that later. Or also three options regarding the formal validity of agreements of succession. First one is to accept the contractual qualification, apply rule of Article 7, which follows, as I already mentioned, named principles of in favorem negotii. Or to, if the agreement of succession deals with succession of the immovables, to apply rule of Article 21, which designates lex recita as applicable to the agreement of succession, or to apply functional qualification to just extend the meaning and the scope of the Article 31 of ZRSE, which deals with the testamentary dispositions, and to apply the law which follows the substantial goal of in favorem testati in particular case, or to determine that there is no special conflict of law rule, that there is a legal gap which at the same time as regard the substantial validity should be fulfilled in accordance with Article 2. So as I already mentioned, okay, we will first discuss whether this is possible, because as I already told you, instinctively does not sound like something that should be done, but some scholarship, because as you know, it's not regulated in our law, we don't have special conflict of law provision. When they were faced with the issue what to do, they thought, okay, if we apply the contractual qualification, then since in practice there are a lot of agreements of succession regarding immovables, if immovable is situated in Serbia, then the Serbian law would be applicable, but only in the case if we don't apply public policy and we don't deem such an agreement of succession contrary to our fundamental principles, then that would make sense. But it opens a lot of different problems, not just this one. So, for example,
Okay.
yeah,
It makes
so,
no sense.
yeah, it makes no sense. But just in case to speak about it shortly. So, because there is no special conflict of law rule regarding contractual disposition of debt in terms of agreement of succession, we would apply this norm of Article 20.20. But you see that it's how it's designed. It does not respond to the general framework of the connecting factors, which employs characteristic performance and principle. And of course, is explained by firstly, I think in the European context by Professor Kurt Lipstein, it denotes the performance which is the most typical to the particular contract. So that domicile or seat should be applied. Instead of this place where the offerer was domiciled, because the problem is how to determine who was the offerer, because you have a lot of situations where the offering and acceptance of offer cannot be easily fixated and cannot be easily determined, and it does not necessarily depend on the person of the party who is party of the contract. So thereby it basically infringes the main idea of characteristic performance principle. So we would in that case determine that there is a legal gap which should be fulfilled with Article 2 of 0Z. So just to shortly introduce Article 2, it basically says that if there is a legal gap in 0Z, it has to be fulfilled in accordance with the principles of 0Z, in accordance with the principles of our legal order, domestic legal order, and also the principles of private international law. And sometimes in literature they are divided, let's say for like didactical reasons, we speak about principles, different principles of, let's say, legal order, private international law in general, also our private international law, but they are all basically the same. They all emanate from the first and foremost and ground principle of closest connection, which permeates all other principles, which is the basic rule that we would follow in this case. So in this case, we would of course apply the law of the domicile of the seat of the debtor characteristic performance in conjunction, of course, with the escape clause, if there is a factual situation that refers maybe to some other particular order with whom the relationship is more manifestly connected. So, but the problem is that still this rule would only apply to a part of the agreement of succession. So it would only apply to admissibility, substantial validity, binding effects, contact and obligation law effects of the agreement of succession, but it would not touch the issues of the succession effects that arise after the death of the contracting party. And thereby we would still be obliged to divide and basically make the passage of a particular agreement of succession by the virtue of analytical process of filling these gaps. So still it will refer to the application of a different set of rules. So I think that in this case, of course, this particular line of argumentation can lead us to a particular solution, but I think that it is manifestly contrary not just to the nature of agreement of succession, but also to the application of Article 2. So if we approach this problem as an issue of succession law to the first qualification, there the solution would be to apply the nationality of the deceased at the time of death for succession as a whole, so it would also encompass both testate and intestate succession regardless of the type of estate. But the problem with this is that nationality principle at the time of death maybe would not in particular case suffice to respect the principles of legal traffic, legal certainty, legitimate expectation of the parties, because if the party changes its own citizenship and nationality, then the retroactive application of nationalis would maybe contrary to his own personal interests and to the idea of what he wanted to make out of his succession. So we would in this case determine that still, if we can, by the virtue of functional qualification, subsume this question under Article 30, we determine that there is a legal gap by theologically reducing this question from the scope of legal category that deals with Article 30, and then we will try to find some different solution according with Article 2. So here the question is how to follow this step, but I will come to that. And also regarding formal validity of agreements of succession, can they be subsumed under the scope of Article 31, which, as already mentioned, is basically the same, and it integrated the Article 1 of Testamentary Disposition Convention. But the thing is that this article only deals with testamentary disposition, so it does not deal with any other contractual dispositions. So that's the problem. If legislator wanted to emphasize that it can be analogously applied to other issues, he would do that, but he missed to do that. But the problem is that in this case, if there is a possibility to subsume this formal validity of agreements of succession under this article, we would not follow the way of determining a legal gap in particular case, because we would not have any other solution. We would need to choose between Article 31 and Article 7. Article 7 deals with contracts, Article 31 deals with testamentary disposition, and we would provide a different solution, and I will come to that. So, with applying principles on a legal gap with regarding succession law qualification of the issue, first of all, there has to be respected one of the biggest principles regarding status, family, and succession law issues in our convictal law system, and that's principle of nationality. So each of set of rules that deals with succession matters, family matters, status law, they follow mainly the principle of nationality. So we need to respect that in order to not make a problem regarding systematic interpretation of this solution, and to make sure that everything is in line with the spirit of ZRSZ. And also we would, my solution is that we should also find inspiration from ESR, because ESR differentiate between unilateral and multilateral agreements of succession, and we should borrow this, but only with regard to the differentiation with regard to classification, because we would employ different conflict of law rules on those two questions. So solution would be that with regard to unilateral agreements of succession, unilateral those where party designates only one person as an heir, only one party appoints someone as a heir, we would apply nationality the deceased possessed at the time of the conclusion of the agreement as to succession, and not at the time of that. So that would be the change that we did, and it's also the same solution in ERSR. So with eventual problems, it could be solved in this way. But with regard to multilateral agreements of succession, we will have slightly different approach, and that would be to cumulatively apply regular cumulation, regular and distributive. Yeah, regular cumulation denotes the cumulation where there is a demand for application of both involved laws on a particular question. So we would in this case apply cumulatively nationalities of both contracting parties at the time of the conclusion of the agreement of succession, but only to, of course, admissibilities and questions regarding formal requirements of that contract. But when it comes to substantive validity and also effects between parties and stuff, we would also follow the solution from ESR and apply the law of one of contracting party to which the particular agreement of succession is more closely connected. So that would be solution regarding substantive issues. when it comes to formal validity of the contract, we would just slightly modify Article 31 by adding only one connecting factor, which refers to both nationality, domicile, and habit or residence of the contracting party at the time of conclusion the contract, and the nationality, domicile, and habit or residence of the contracting party at the time of that. By this way, we of course follow the main principle of our competence law rules regarding the formal validity of contracts and other issue, which is in favorem negotii, or to make contract retain its power regardless of the applicable law. And concluding remarks, I didn't deal with the questions of public policy or what will happen in a particular case, regardless of whether our court would be about to handle a particular agreement of succession on which the foreign law is applicable or Serbian law is applicable at Lex Fori. I think that I, of course, agree with Professor that there is no, because there are no reason to consider agreement abstractly violating public policy as such. We should first look at the content, as my colleagues also emphasize, and thereby we can make any significant conclusions with regard to that. And thank you very much. And if you have any questions, do not hesitate to ask me now or later.